Ready, start. Learn. Senior counsel for the respondent, Mr. Nair, with considerable vehemence, supported the impugned order and made fourfold submission. First, it was submitted that for grant of relief under the Consumer Protection Act 1986, it is imperative for the consumer to prove actual loss or injury to him due to neglect of the other party. Full stop. Reference was made to Section 14 of the Act, which reads thus: finding of the district forum, if after the proceeding conducted under Section 13, the district forum is satisfied that the goods complained against suffer from any of the defect specified in the complaint, or that any of the allegation contained in the complaint about the services are proved, it shall issue an order to the opposite party directing him to do one or more of the following things, namely donation, charity and samaj seva, to pay such an amount as may be awarded by its consumption, and compensation to the consumer for any loss or injury suffered by the consumer due to the negligence of the opposite party. Full stop. Therefore, evidence must be laid to prove actual loss suffered by the consumer before the grant of compensation. Full stop. Grant of compensation cannot be beyond actual loss and cannot venture into the territory of gain-based remedies. Full stop. In the present case, while the respondent claim for charging interest at the rate 18% on 7th the Act 8 default is supported by the agreement, the appellant's claim for grant of interest at the rate 18% cannot be sustained, as he did not lead evidence to prove the actual loss. Full stop. In support of these propositions of this place on the subject of this court in Ghaziabad Development Authority versus Balbir Singh and Fortuner Infrastructure versus TD Lima. Secondly, a consumer cannot, as a matter of routine, be awarded compensation at the rate charged by the builder under the contract. Full stop. This code has granted a 9% interest rate to the consumer for deficiency in services. Full stop. Thirdly, this code has constructively rejected the claim of consumer who claimed parities with the builders in interest charged on delay payment. Full stop. This was placed upon the judgment of this court in the Grace Real Tech Private Limited versus Abhishek Khanna, where this court held we have considered the rival submission made by both the parties. Full stop. The delay compensation specified in the apartment by the agreement of rupees 7.5 per square foot, which translates to 0.9% to 1% per annum on the amount deposited by the apartment buyer, cannot be accepted as being adequate compensation for the delay in the construction of the project. Full stop.